Okay, so good afternoon, good evening, good morning, depending on whatever time you are watching this. And thank you for joining. I hope this will be helpful to at least one person. Okay. So, okay, guys, today we're going to be talking about action or application, right? So imagine this. You go to court with a case you think is strong. Your client has the documents, your client has the story, your client is ready. You walk in confidently thinking, today we are getting justice. But then the judge looks at your papers and basically says, Counsel, this matter should not have been brought this way. Just like that, your whole case is in trouble. Not because your client is wrong, not because the facts are impossible, but because you chose the wrong procedure. And that, guys, is why today's topic matters, right? In civil procedure, it's not enough to know that your client has a claim. You must know how to bring that claim before court. Because in court, the route matters. If you choose the wrong route, you can waste time, waste money, frustrate your client, and make a strong case look weak. Okay, so today we're dealing with one of the most practical questions in civil procedure. Do we proceed by way of action or do we proceed by application? And trust me, once you understand this topic, civil procedure will start making much more sense. It's not going to be as difficult as you think. But now, before we continue, guys, if you are studying law and you want more lessons explained in simple, clear, exam-ready language, make sure you subscribe to the channel. If you want deeper case breakdowns, full exam answer guides, members-only tutorials, then consider joining the membership as well. It supports the channel and it helps me to keep creating these lessons for you. Now let's get into it. Let me start with a short story. Imagine your friend owes you 20,000 rand, not 200, not airtime money, a full 20,000 rand. You've been very patient with this guy. You've been so understanding. You've sent polite messages. You have even used dangerous phrases to be like, look, no stress, dude. Just pay me when you can. But now, 6 months down the line, this person is posting soft life photos in Cape Town, eating sushi, buying sneakers. Every caption is like God's timing, poverty is a state of mind, wada, right? And you now say, enough is enough. I'm going to court. But here's the problem. You can't just run to court and say Your Honor, this person is moving funny with my money. Court doesn't work like that. Civil procedure is not vibes. Civil procedure is a system. It has roots, it has documents, it has rules. And before you even ask, will I win? You must first ask, which procedure must I use to bring this matter before court, right? This is why today we're talking about action or application, right? So now I want you to picture civil procedure like Google Maps, right? You type in your destination like I want justice, right? And then the law asks you, which route are you taking? There are two main routes. The first route is called action, the second route is called application, right? Both can take you to court, but they're not the same road, right? One road is long, detailed, and it involves a full trial. The other road is quicker, it's paper-based and usually decided on documents, right? But here's the dangerous part. If you choose the wrong road, your case can get stuck, right? You waste time, you waste money, you embarrass your client, and you embarrass yourself. And in practice, choosing the wrong procedure can be the difference between looking like a good lawyer, a great lawyer who knows what they're doing, and looking like someone who just copied and pasted from Google Documents, right? Trust me, I'm not a lawyer yet, but I've got my degree. Okay, so today we are not just we're not just going to define action and application. We're learning to think like people already have their LLBs. Okay. By the end of this lesson, you must be able to answer 3 questions. First, what is an action and what is an application? Second, how does each procedure work in High Court and Magistrate Court? And then number 3, and most importantly, how do you choose between action and application when you're given a legal problem, right? And the main case that will help us to answer that, that will help us to answer the third question is the room hire case, right? That case is important because it gives us the heart of the test. It teaches us that the choice between action and application depends mainly on whether there is a real dispute of facts, right? Now, don't panic. You've heard that before, a real dispute of facts, right? I'm going to break it down properly in simple terms. You know, a real dispute of fact means that the parties are fighting about what actually happened, and the court cannot fairly decide the matter just by reading papers, right? So let's go back to the 20,000 Rand scenario. So if your friend says, yes, I borrowed the money, yes, I signed the acknowledgement of debt, yes, I have not paid, then there is probably no serious factual dispute, right? So the court can look at the documents and say, okay, the debt exists, so that kind of matter can be suitable for application, right? But if your friend, on the other hand, says, no, that money was not a loan, it was a gift. You gave it to me because we were close, and now we have a problem. And then one person says it's a loan, then the other person says it's a gift. So the court must now decide whose version is true. So that may require witnesses, WhatsApp messages, cross-examination, and a proper trial, right? So now that kind of matter is usually better suited to an action. So already, before we define anything formally, you can now see the picture. You can now understand what is action and what is application, right? So application is for matters the court can decide on paper. Remember that. Action is for matters where the court may need a trial to test the truth, right? So this is the whole lesson in its simplest form. So now let's slow down and define the 2 procedures properly. An action is a civil procedure that normally leads to a trial, right? The person who starts the action proceedings is called the plaintiff, and the person being sued is called a defendant. In an action, the parties exchange pleadings, prepare for trial, call witnesses, lead oral evidence, cross-examination, witnesses, and then the court gives the judgment, right? So when you hear the word action, I want you to think trial, witnesses, oral evidence, cross-examination, plaintiff, and defendant, right? And an application, on the other hand, is a paper-based procedure. It is also called motion proceedings, right? So the person who brings the application is called the applicant, and the person opposing is called the respondent. So in an application, the parties usually do not call witnesses. Instead, they place their evidence before the court in affidavits, right? The court reads the affidavits, listens to the legal argument, and then gives a decision. So when you hear the word application, I want you to think papers, affidavits, notice of motion, applicant, and respondent, right? Now, let me make it even more simple, right? An action is like saying, Judge, these people are fighting about what happened. Please hold a trial so that witnesses can come and be questioned. An application is like saying, Judge, the facts are clear enough. Please read the documents and make a decision. That is the key difference. Now, guys, let's explain the action process in a simple way. An action usually starts with a summons, right? A summons is the document that calls the defendant to court and tells the defendant that a claim has been brought against them, it's like the formal message saying you are being sued, right? So the summons will usually be accompanied by particulars of claim, which explain the plaintiff's case. The plaintiff must say what happened, what legal right was violated, and what remedy they want. And then after receiving the summons, the defendant can decide whether to defend the matter. If the defendant wants to oppose the claim, the defendant enters an appearance to defend, right? So this is basically the defendant saying, I'm not just going to accept this claim, I'm going to fight it. And after that, the parties exchange pleadings, right? So now, what are these pleadings? Pleadings are formal court documents where the parties set out the material facts of their case. The material facts are the important facts that matter to the case. So pleadings are not there to include every single detail or every piece of evidence. They are there to define the issues. So in simple terms, pleadings tell everyone what the fight is about, right? For example, if I sue you for breach of contract, my particulars of claim must explain that there was a contract, what the terms of the contract were, how you breached the contract, and what I'm claiming because of that breach, right? Your plea must then say what you admit, what you deny, and what your defense is. Maybe you say there was no contract. Maybe you say there was a contract, but you did not breach it. Maybe you say you did breach it, but I suffered no loss, right? The pleadings help us identify the real issues. So after the pleadings, we move to the pre-trial stage. The pre-trial stage is the preparation stage before the actual trial, right? So this is where the parties prepare documents, exchange information, discover documents, arrange witnesses, and get ready for court. Discovery means the parties must disclose relevant documents to each other. For example, emails, invoices, contracts, photographs, reports, bank statements, you name it, may be discovered if they are relevant to that particular dispute. Then we get to the trial. So at trial, witnesses give evidence. The plaintiff usually leads evidence first. The plaintiff's lawyer asks the plaintiff's witnesses questions. This is called examination in chief. You already know that most of you have done mock trials, right? Then the defendant's lawyer gets to question those witnesses. It's called cross-examination. Cross-examination is very important because it tests the witness's version. After that, there may be re-examination where the original lawyer asks follow-up questions to clarify issues. Once all that evidence is finished, the parties then present their legal argument, and then the court gives the judgment. So action proceedings are longer because they are designed for cases where the court must hear and test evidence, right? So now let's talk about application proceedings. So an application usually starts with a notice of motion and a founding affidavit. The notice of motion tells the court and the respondent what order the applicant wants. For example, the applicant may ask the court for an interdict or a declaratory order, a review, or an order compelling someone to do something. So the founding affidavit is where the applicant sets out the facts and the evidence supporting the application. So if the respondent wants to oppose the application, the respondent files an answering affidavit. This is where the respondent answers the applicant's allegations. The respondent must admit, deny, or explain the facts, right? If the respondent denies something, they must not just say, I deny it. They should explain why they deny it and put up their own version. After the answering affidavit, the applicant may file a replying affidavit where the applicant replies to the new issues raised by the respondent. Okay, so the important thing to understand is this. In application proceedings, the affidavits are extremely important because they contain both the facts and the evidence. In action, right, pleadings and evidence are separate. In an application, affidavits do both jobs. The affidavits tell the court what the case is about, and they also provide the evidence. That is why we say application proceedings are decided on papers. So guys, let's pause here for a second, because this is where people lose marks, right? You know the definitions, but then you can't apply, you can't apply that to the problem question. So don't just memorize actions cost to trial and applications cost to papers. You must understand why the law separates them, right? So if this explanation makes civil procedure feels less scary, please hit the like button so that more law students can find this video, and also subscribe if you want more topics explained like this, not in a complicated textbook language, but in a way that actually makes sense. Now, let's come to the most important question in this whole lesson. How do we choose between action and application? Okay, so the answer is this. We ask whether there is real dispute of fact on a material issue. So now let's define that properly. A dispute of fact means that the parties disagree about what actually happened. A real dispute of fact means that the disagreement is genuine, is serious, not just made up to delay the case. And a material dispute of facts means the disputed fact is important enough to affect the outcome of the case, right? So let's make it easy. So if I say you owe me 20,000 rand because I lent you money, and you say no, you never lent me money, but and you say no, you never lent me money, right? So this is a dispute of fact. If I say you signed the written contract and you say that is not my signature, that is a dispute of fact, right? If I say you crashed into my car because you skipped the red light, right? And you say no, the light was green, that is a dispute of fact. These are not small side issues. These facts matter to the outcome, so they are material, right? But if we agree on the main facts and only disagree about the legal result, then an application may be suitable. For example, if both parties agree on what documents were signed, what date things happened, and what decision was taken, but they disagree about whether the decision was lawful, then the court may decide the matter on application, right? Now, guys, every topic that has every topic that has that one case that becomes the main character. For this topic, the main character is room hire, right? The room hire case. So this is the case that you must not ignore. If you're writing a test or an exam, and the question asks whether a matter should proceed by action or application, you must immediately think room hire, right? This case gives us the practical test. It tells us that the key question is not simply which procedure do I prefer. The key question is there a real dispute of fact on a material issue? That is the phrase you must always remember. Is there a real dispute of fact on a material issue, right? A real dispute of fact means that the parties are genuinely fighting about what happened, right? A material issue means the fact that they are fighting about actually what they are fighting about actually matters to the outcome of the case. So if the dispute is real and important, the matter usually needs action. If there is no real factual dispute and the court can decide the matter on the documents, then an application may be suitable, right? Now let's go back to the room hire case properly. So in room hire, the court explained that there are basically three situations when deciding whether to proceed by action or application. The first situation is where the law says you must use application proceedings. In other words, a statute may require that that matter to be brought by application. So if the law says use application, then you use application. You don't choose action just because you prefer it. A simple example will be certain types of insolvency or company matters where legislation requires application proceedings, right? The second situation is where the law or the nature of the matter requires action proceedings. For example, if you are claiming unliquidated damages, you will usually use action proceedings, right? Unliquidated damages are damages that are not already fixed or easily calculated. For example, damages for pain and suffering, emotional shock, future loss of income, or general damages normally need evidence to prove the amount, right? A court may need to hear witnesses, experts, cross-examination, so action is usually the correct procedure. The third situation is the gray area, right? So this is where the law does not clearly force you to use one procedure. In that gray area, the key question is whether there is a real dispute of fact. If there is a real dispute of fact, you should use action. If there is no real dispute of fact, you may use application. Now, guys, this is the sentence I want you to remember for exams. I'll repeat it 2 times. I want you to remember this. If the court can decide the matter on papers, it's application. If the court needs oral evidence and cross-examination to decide whose version is true, action is suitable. Okay, I'll say it again. If the court can decide the matter on papers, then it's application. If the court needs oral evidence and cross-examination and the whole enchilada to decide whose version is true, action is suitable, right? So let's put it in a simple language. If the judge can read the documents and say, I understand what happened, I can decide this, then application may work. But if the judge needs to hear people speak, watch how they answer, how they answer to their questions and decide who is lying and who is telling the truth, then action is the better route. Now we must discuss something very important. Not every denial creates a real dispute of fact, right? Sometimes a respondent will oppose an application just to delay the matter. They may say, I deny everything, but they give no proper explanation. This is called a bare denial. A bare denial is a weak, empty denial. It is when someone denies a fact without seriously engaging it. So let me give you an example. Imagine I say, you borrowed my laptop on Monday. Here's the WhatsApp where you asked for it. Here's the CCTV footage of you collecting it. Here's your message saying you will return it on Friday. And then you respond by saying, I deny that I borrowed the laptop. That is not enough. You must explain, are you saying the WhatsApp message is fake? Are you saying the on the CCTV footage is not you? Are you saying you returned the laptop? Are you saying someone else collected it? If you give no explanation, your denial may be a bad denial, right? So the courts don't allow respondents to defeat application proceedings by simply denying everything in vague terms, right? Just 1 second. Okay. So the courts won't allow the respondents to defeat application proceedings by simply denying everything vaguely, right? So if that were allowed, application proceedings would become useless because every respondent will just say, I deny, I deny, I deny. You know, that's why the courts take a robust and common sense approach, right? This is where Sophiantini and Mould case is important. In that case, the court warned that if a mere general denial could defeat an application, motion proceedings would become worthless. So the court said it must not be too cautious or over technical when dealing with disputes raised on affidavit. The court must use common sense. Justice can be delayed if courts allow respondents to create fake disputes by using bare denial. So now, before we move on, there is one more case that you need to know, right? That is the rapers versus rapers, right? I don't want us to treat this case as a completely new topic. Think of rapers as a modern example of the principle we have already discussed in Room Hire. So in Reapers versus Reapers, the court had to deal with a matter that came before it by way of application. Remember what we said about applications. They are meant to be decided on paper, meaning on the affidavits and documents before the court. But the problem was that the matter involved a dispute of fact. The court had to consider whether the dispute on the papers was genuine and whether it could be resolved properly without oral evidence. So guys, why is the Reapers important for us? It shows that Room Hire is not just an old case sitting in a textbook. The same principle still applies today. So if parties are fighting about important facts and the court needs more than affidavits to decide who is right, then application proceedings become dangerous. The applicant cannot simply force the court to decide on uh, to force the court to decide a factual fight on paper, right? So imagine two people are fighting about property, money, or rights after a relationship is broken down, and one person brings an application and says, court decide on this on the document, right? But the other person says, no, the documents don't tell the full story. There are serious factual issues here. And if those factual issues are real and material, the court may say this cannot be properly decided on application. That is the whole point of the Reapers case. So in an exam, you can use Reapers versus Reapers as your modern supporting case, right? You can simply say in Reapers versus Reapers, the court confirmed the importance of identifying whether a genuine dispute of facts exists on papers. Where such a dispute cannot properly be resolved on affidavit, the court may have to consider oral evidence or trial proceedings instead of deciding the matter purely on application. So that is all you need from Reapers for the purposes of action or application, right? Room Hire gives you the main test. Reapers shows that the same test still matters in modern civil procedure, but Room Hire gives you the main test, right? So now let's connect this back to our learning outcomes, right? So we say the first learning outcome say that you must understand the basic of action and applications in the High Court and Magistrate Court. That means you must know that both the High Court and Magistrate Court deal with civil procedure, but the basic distinction remains the same. Actions are trial-based and applications are paper-based, right? And then the second learning outcome is that you must be able to illustrate the process of action and application proceedings, right? So when asked about action proceedings, you must explain someone's appearance to defend, pleadings, pre-trial procedures, trial, oral evidence, cross-examination, and all that, right? But when we asked about application proceedings, you must explain notice of motion, founding affidavit, answering affidavit, replying affidavit, hearing legal argument, and the judgment, right? And the third outcome says that you must understand the factors that influence the choice of process and apply these to legal problems. This is where you must be able to use Room Hire. You must ask whether the matter is required by legislation to be brought by application, whether it must be brought by action or whether it falls into the gray area. If it falls into the gray area, you must ask whether there is a real dispute of fact on a material issue. So now, just a quick example before we end this. Imagine Apiwe wants to recover 50,000 Rand from Lindo, right? Apiwe says Lindo signed a written acknowledgement of debt. The document says Lindo owes me 50,000 Rand and must pay it by 30 June. Lindo responds and says, I admit I signed the AOD and I admit I have not paid. I just don't want to pay it right now. So in this case, there is no real dispute of fact. Lindo admits the important facts and the issue is clear. Apiwe may use application proceedings because the court can decide the matter on documents. Now, turn things around. Lindo owes me money because we had an oral loan agreement, and Lindo says no, that money was not a loan. It was money that Apiwe gave me as a birthday gift. Now there is a real dispute of fact. Was it a loan or was it a gift? So the court may need to hear evidence. The court may need to hear what was said, what the parties intended, and whether there were messages or witnesses. This matter should usually proceed by way of action, right? So this next part is very important, because this is where we move from understanding the topic to actually answering the exam question. And honestly, this is where marks are made, right? Knowing the law is one thing, and writing it properly under the exam pressure is another thing. So I said this once again before I close. If you want full members only videos where we take problem questions and answer them step by step, make sure you check out the membership section. That is where we go deeper: structure, wording, cases, application, and how to write like someone who actually understands civil procedure. Now let's prepare for how to answer an exam question. So if the exam asks, should X proceed by action or application, your answer must not be random. You start by saying the issue is whether the matter should be brought by way of action or application. Then you define both. Then you discuss room hire. Then you apply the real dispute of facts test, right? And then you conclude, right? So that's basically it. You don't need to go from Joburg to Cape Town via Mpumalanga or something like that. I don't know. So just remember this: action equals to trial, application, papers, action, plaintiff and defendant, application, applicant and respondent, action, summons, application, notice of motion, action, oral evidence, application, affidavits. Action is used where there is a real dispute or a real factual dispute. Application is used where the court can decide the matter on documents. And finally, the room hire principle. Where there is a real dispute of fact on a material issue, proceed by way of action. Where there is no real dispute of fact, application may be appropriate. Guys, remember, if you remember nothing else from this video, right? Just remember this: the court route must match the type of dispute. If the facts must be tested, you go by action. If the papers are enough, you go by application. If this video helped you, or if any part of this video helped you, please like the video, subscribe to the channel, and share it with your friends who are suffering in silence. Okay, we must finish this degree together. Thank you so much, guys, and all the best.